Hello and welcome everyone. This is the ninth session of the Education and Training Series organized by Africa in the Moot with the support of our media partner, the Arbitration Channel, and the context of the 31st Vis Moot competition. For those of you that are joining us for the first time today, Africa in the Moot is a nonprofit, volunteer-based organization that is aimed at increasing the participation of sub-Saharan African students in the Vis Moot competition. My name is Bethel Casa. I am a member of the Education and Training Committee of Africa in the Moot and an associate at Morgan & Morgan based in Washington, D.C. I'm happy to be joined today by Radhika Arora, who is the chair of the Development Committee of Africa in the Moot and also an associate at Oraro and Company Advocates in Nairobi, Kenya. Today, we'll be discussing a very interesting topic, which is consolidation of claims under ICC Arbitration Rules, which is one of the main issues in this year's Moot problem. To guide us through this intricate but fascinating, interesting topic is Thomas Snider. Tom is a partner and the head of international arbitration at Charles Russell Speechlys, based in the firm's Dubai office. He is experienced in international commercial arbitration, international investment disputes, state-to-state arbitration, and foreign sovereign immunity issues. Tom is recognized as a thought leader in who is who legal arbitration and is ranked for dispute resolution in Chambers United Arab Emirates. He was also named to the Legal 500 Private Practice Arbitration Power List Middle East region in 2022 as well as in 2023. Among numerous other roles, Tom is a member of the board of directors of the Dubai International Arbitration Center and the Court of Arbitration of the Singapore International Arbitration Center. Prior to relocating to Dubai, Tom was a professorial lecturer in law at George Washington University Law School. And fun fact, from 2001 to 2009, Tom was a member of the legal team representing the Ethiopian government before the Eritrea-Ethiopia Claims Commission, which is an international arbitral tribunal that adjudicated claims for loss, damage, and injury arising during an international armed conflict. In this context, he worked as a resident attorney in Addis Ababa for 3 years. Before I hand over the floor to Tom, I would like to remind our audience that you may ask your questions using the chat function in the arbitration channel, and Tom will be addressing those questions at the end of his presentations. Also, I would like to remind our audience to bear in mind that our speakers cannot provide solutions or answers to specific questions in the Moot problem. So please keep that in mind while formulating your questions. With that housekeeping rule, I give the floor to Tom Snider. Tom, the floor is yours.
And hello, everyone. It's a real pleasure to take part in this and spend the next hour or so discussing consolidation under the ICC rules with all of you. I like the way that Bethel described consolidation as intricate but fascinating. It is quite an intricate topic. I hope to not get too bogged down in the details and certainly hope, though, that you'll bear with me as we get into the nitty-gritty of some of these issues. I think consolidation is an area that is often quite fact dependent. There are sort of, in many respects, different ways that issues can be looked at. And I may raise as many questions as I provide answers. So do bear with me in that regard. So to get started, let's just take a step back and think about this conceptually. I think if you think about it conceptually, in an ideal world, when you have a dispute that maybe involves multiple parties, different contracts, different claims, ideally it's good to have that, to be able to have that dispute resolved in one forum. It's cleaner, it's more efficient, makes sense for the parties involved to do that, if you can do that. And certainly, I think if you look at the way the world operates in international trade and commerce in particular, there frequently are situations where you have multiple parties, multiple contracts, multiple claims. Think of construction projects, for example. You have the employer, the engineer. You may have one or more contractors, several subcontractors. And when a dispute arises, it may affect each of these actors in different ways. There may be and typically are different contracts in place between these various parties, and the dispute is often complex. If you think of mergers and acquisitions, especially in the international context, you may have multiple buyers, multiple sellers, multiple shareholders. You frequently have joint ventures and consortiums in these international projects. Again, multiple parties, multiple contracts, and multiple claims. When you look at national courts, frequently, to the extent they have jurisdiction over all the parties, they have the ability to bring those parties in and resolve the dispute in one forum. Historically, arbitral tribunals were quite limited in their ability to do that, to bring these different parties, contracts, and claims into one forum. But over time, arbitral institutions have adapted their rules to expand the ability for arbitral tribunals to resolve such disputes in one forum. There are different mechanisms for doing so. I think most notably joinder, which is the ability to add an additional party to an arbitration, and consolidation, which is the consolidating or combining of multiple arbitrations into one arbitration. And of course, consolidation is our topic for today. Now, over the next hour or so, we are going to focus on the ICC rules, but my first slide, I'm going to quote the ICSID Rules, the International Center for Settlement of Investment Disputes, which focuses, as its name implies, on investment disputes, not commercial arbitrations. But the reason I'm starting with this ICSID rule number 46 of the ICSID rules, of the new ICSID rules, which just came into force in 2022, is that I like how this rule sort of sets up the dichotomy between consolidation of arbitrations and coordination of arbitrations. And I think this is helpful to distill any confusion that might arise as to what consolidation really is. Under Rule 46.2 of the ICSID Rules, it says that consolidation joins all aspects of the arbitration sought to be consolidated and results in one award. And I think it's important to recognize that when you are talking about consolidation, you are talking about merging multiple arbitrations into one arbitration. So you've got multiple parties brought into one arbitration before an arbitral tribunal that will presumably issue just one award in that arbitration. This can be contrasted with coordination of arbitrations, which I think is sort of something that's catching on a bit in international arbitration. Under the ICSID rules, they describe this as aligning specific procedural aspects of two or more pending arbitrations, but the arbitrations remain separate proceedings and result in separate awards. So, for example, I had a case a few years ago under the old DIFC LCIA arbitration rules, which are no longer in effect. But there we were representing the respondent. Two different but related claimants had brought claims against our client. They sought to have the two arbitrations consolidated. The criteria for doing so were not met, but the DIFC LCIA appointed the same arbitrator in both arbitrations. We had similar procedural timetables. We issued separate written submissions in each arbitration, and ultimately 2 awards were rendered, 1 for each arbitration. Had they been consolidated, presumably the proceedings would have been more compact and only 1 award would have been issued. If we move on, what are sort of the advantages of consolidation? I think broadly speaking, there are 2 main advantages, efficiency and avoiding inconsistency. By having consolidation, you can have more effective case management, reduce time, costs, and inefficiencies of having multiple proceedings. You can also ensure that you do not get conflicting or inconsistent decisions rendered in the multiple arbitrations that would take place if they were not consolidated. On the flip side, what are the, and I struggled here a little bit, I don't really like saying disadvantages, but what are the disadvantages or challenges or pitfalls or difficulties that one might encounter when you're talking about consolidation, when you're affecting consolidation in international arbitration? I think the first issue that you really need to keep in mind is sort of the issue of consent, right? Consent is the cornerstone of international arbitration. Parties agree to arbitrate in their arbitration agreement. It's a creature of contract, it's a creature of agreement. Parties know who their counterparty is, or should know who their counterparty is when they agree to arbitrate. If you're consolidating multiple arbitrations and you're bringing in different parties, then you start to encounter issues relating to consent and contractual privity. Think about the construction example for a moment. You have the employer, you have the contractor, and you have the subcontractor. Typically, there will be a contract in place between the employer and the contractor, and then there'll be a separate contract in place between the contractor and the subcontractor. But there typically won't be a contract in place between the employer and the subcontractor. There'll be no contractual privity there, and at a broad level, no consent to arbitrate between the employer and the subcontractor. So these are some issues that you need to think about when you're talking about consolidation. And as we'll see, these issues can be implied or addressed in the rules of arbitral institutions when it comes time to consolidate cases. Relatedly, you have the issue of confidentiality. If you've got multiple parties that have not entered into a contract with one another, there may be concerns about confidentiality. Another issue that we need to think about when we're talking about consolidation is ensuring the fair and equal treatment of parties. To ensure that the parties are treated fairly and equally when it comes to procedural matters. And I think most notably, when you're talking about consolidation, fair and equal treatment in terms of the appointment of arbitrators. There's a fairly well-known case that came about some years ago that sort of highlights this issue. If I recall correctly, this case didn't arise in the context of consolidation itself, but some of the issues that were raised certainly do apply in the context of consolidation, and that's the Dutco case, D-U-T-C-O. In that case, which was an arbitration administered by the ICC, a claimant brought claims against 2 respondents that were part of a joint venture. Each of the respondents felt that it was entitled to appoint its own arbitrator. The 2 respondents couldn't. The arbitration agreement called for 3 arbitrators. The claimant appointed one. The respondents could not agree on a second arbitrator, and each wanted to appoint their own. The ICC stepped in, nominated an arbitrator for the respondents, and then of course a presiding arbitrator, which the respondents accepted under protest and then subsequently challenged the award before the French courts. The French courts determined that in this situation, the parties were not being treated equally. The claimant had the opportunity to appoint its own arbitrator, whereas the two respondents did not. As a result of that, we see in the ICC rules, and we see in the rules of several other arbitral institutions, the ability of the arbitral institution to step in and make appointments to ensure the equal treatment of the parties. And you can see on the slides here where that appears in Article 12.9 of the ICC Arbitration Rules. Now, one other issue that I'll note, and notwithstanding what I said earlier, you'll see the last bullet point here is delay with a question mark beside it. I said earlier one of the advantages of consolidation is time and cost savings. But certainly from the perspective of certain parties, consolidated proceedings might take longer than anticipated. Using the construction scenario once again, you can imagine a case where a subcontractor has a relatively straightforward claim for non-payment against the contractor, and in theory, that dispute could be resolved relatively quickly in an arbitration that takes place simply between the contractor and the subcontractor. But if the subcontractor finds itself in an arbitration consolidated with the contractor and the employer, where there may be complicated issues of delay and quantum at play between the contractor and the employer, it could take much longer than anticipated for the subcontractor to have its dispute resolved. So it's just something to think about there. Timing can cut both ways. I'll move now to sort of the meat of the issue, the meat of today's topic, and that's Article 10 of the ICC Arbitration Rules, which deals with consolidation. I don't have it on the slide here. I probably should have included it, but the title of Article 10 is Consolidation of Arbitrations. Now, I'm going to spend a little time, there's quite a bit here. I'm going to spend a little time unpacking this, and I may be flipping back and forth a bit between slides, but bear with me and we'll try to get through this. I won't read it word for word at the outset because there's too much here, but if we start off looking at Article 10, it says that the court, and that's the ICC Court of Arbitration, it says the court may, at the request of a party, consolidate two or more arbitrations pending under the rules, under the ICC rules, into a single arbitration, and then it provides sort of three sets of criteria for doing so. Before we march through each of the criteria, I just want to unpack this introductory text. It's interesting to note that the ICC rules place the decision of whether to consolidate with the ICC Court of Arbitration itself. There are different approaches taken by different arbitral institutions in this regard. SIAC, the Singapore International Arbitration Center, has a fairly detailed rule on consolidation that in some instances leaves the decision to be made to the SIAC Court of Arbitration, but in other instances leaves it to an arbitral tribunal. The LCIA takes a similar approach, sort of leaves a decision to the tribunal, although with the input of the LCIA court itself. But under the ICC rules, the decision is to be made by the court. I I think this is interesting in terms of the Vis Moot problem this year. Again, I'm not giving anyone any pointers, but many, if not all of you, will note that the arbitration agreement at issue in the framework agreement in the Moot problem does purport to give the arbitral tribunal decision-making power when it comes to consolidation. And so that's something that you'll have to grapple with as you develop your arguments in the case, how that sort of sits with Article 10 of the ICC Rules. It's also important to bear in mind under Article 10 that the ICC Court's decision-making power when it comes to consolidation is discretionary. It uses the word may grant consolidation, not shall grant consolidation. So even if some of the criteria that we'll be discussing in Article 10 are met, that doesn't necessarily mean that the ICC Court has to grant the consolidation application. There is quite a bit of discretion left to the ICC Court. I think another interesting question when you're considering Article 10 is whether the court's decision can be reconsidered by the arbitral tribunal. I think if you look solely at Article 10, the answer is probably that it can't be, that it is a final decision made by the court. Let me just go back to the rule for a moment, and then we'll jump ahead 2 slides. Okay, so we've got sort of 3 sets of criteria that can be met when a party or parties want to consolidate. I think the first criterion is relatively straightforward. The ICC Court can consolidate 2 or more arbitrations if the parties have agreed to consolidation. I think broadly speaking, in practice, you don't see a lot of arbitration agreements where the parties have affirmatively agreed at the outset to consolidate cases. Here again, this year's Vis Moot problem, I think it's in the framework agreement. There is some language where the parties appear to have agreed on consolidation, and again, you'll have to grapple with that. But in practice, we just don't see that very often. On occasion, you do, but not very often. We do see some instances in practice where once the disputes have arisen, the parties will agree to consolidation. But here again, I would say that's relatively infrequent. Others may have different views on that, but sort of in my experience, I've seen some examples where the parties have agreed to consolidate once the dispute has arisen, but not a lot of that. So if we go on to the next set of criteria, and this is where I think it starts to get interesting. I think this is where it starts to get intricate, to use Bethel's words. So bear with me. What I've done is, in just a moment, I'm going to take you to another slide where I've come up with some graphic designs that I hope will help to make this easier to follow, but we'll see. So the next criterion in Article 10 says that the court may consolidate where all of the claims in the arbitrations are made under the same arbitration agreement or agreements. Now, what does that mean? If we look at, so when the ICC issued the ICC Arbitration Rules in 2021, they also issued a note to parties and arbitral tribunals on the conduct of arbitration, where they fleshed out some of these issues in the rules and provide, in some cases, provide examples. Now, in relation to Article 10b, the ICC Note to Parties and Arbitral Tribunals gives this example, which I've tried to show here in this slide. It says that, for example, parties A, B, C, and D parties to a share purchase agreement and a shareholders agreement. And then it says parties A and D are parties to arbitration number 1, while parties B and C are parties to arbitration number 2. In such a scenario, consolidation of arbitrations 1 and 2 may be possible. So we've got 4 parties that are all party to 2 different agreements: the SPA, the share purchase agreement, and the SHA, the shareholders agreement. It's not clear from the note, but the assumption seems to be that in arbitration number 1, party A has claims against party D under both the SPA and the shareholders agreement. Again, that's not clear from the note, but I'm assuming that's the case, so that there are claims under both of these arbitration agreements. And then in arbitration number 2, here it's party B against party C, and again the assumption seems to be that there are claims under both the SPA and the SHA. According to the ICC Note, in this situation, since all of the claims in the arbitrations are made under the same arbitration agreement or agreements, which is the case here, multiple agreements, consolidation could be granted by the ICC Court of Arbitration. I'm going to come back to this in a minute because I think you can play with this a little bit, add some variations, and quickly raise some questions that where the answer to whether or not the cases could be consolidated are not as clear, but I'll come back to that in just a moment. Then the last set of criterion in Article 10 is in Article 10C, and I'm going to try to go back. So Article 10C says that the court may consolidate 2 or more arbitrations where, and bear with me here, there's a lot to unpack here, where the claims in the arbitrations are not made under the same arbitration agreement or agreements, but the arbitrations are between the same parties, the disputes in the arbitration arise in connection with the same legal relationship, and the court finds the arbitration agreements to be compatible. Now there's a lot here, and we'll try to walk through this. And once again, based on the ICC Note, I've got another graphic that I hope will help us break this down. But let me read you what the ICC Note says about Article 10C. The example it provides here says that assume the arbitration number 1 is between parties A and B with claims under a SPA arbitration agreement, a share purchase agreement, and that arbitration 2 is between the same parties, A and B, with claims under a shareholder agreement. In that scenario, consolidation may be possible if the disputes in the arbitration arise from the same legal relationship and the court finds these arbitration agreements to be compatible. So here, we've got the same parties in the 2 arbitrations, but the claims are brought under different agreements. So in the first agreement, claims under the SPA, in the first arbitration, claims are brought under the SPA only. In the second arbitration, claims are brought under the shareholders agreement only. So same parties, different contracts. What are the other criteria that need to be met here? According to Article 10C, the next criterion that needs to be met is that the parties must have the same legal relationship. Now, I've got to tell you, I grapple with this phrase, this concept, same legal relationship. It's not defined in Article 10. I'm not sure I'm entirely clear what it means. I think it must mean something broader than the same contract, because that's exactly what Article 10C is trying to get at. sort of claims that are not brought under the same contract. Does it mean some sort of contractual relationship? That's not entirely clear. But in the early days, soon after, I think this term, if I'm not mistaken, first appeared in an earlier version of the ICC Rules that came out in 1998. And Anne-Marie Whitesell and Eduardo Silva Romero, who were respectively the former ICC Secretary General and Deputy Secretary General, indicated that the same legal relationship would appear to mean the same economic transaction. That's probably a fair description in my view, but again, it's not entirely clear. And I think if you apply it to the example that we're looking at on the slides, if you assume the SPA and the shareholders agreement do relate to the same economic transaction, then that definition does make sense. You would expect to have the ability to consolidate arbitrations related to the same economic transaction, and so that would probably apply here. Now in Article 10C, the last criterion that needs to be met, which again I think is an interesting one, is that the arbitration agreements need to be compatible. Now, in the example given in the note in relation to Article 10C, we don't know what the arbitration agreements look like. We don't know if they're compatible or not. But in general terms, what are we looking for? What are we talking about when we say arbitration agreements are compatible or not compatible? Again, compatibility is not defined, probably by design in Article 10. But what would make an arbitration agreement compatible or not compatible? I think, in my mind, probably the key, the starting point is, what is the seat of arbitration? If you have different seats of arbitration, almost certainly, I think, in my view, the arbitration agreements will not be compatible. They'll not be compatible because you will have different procedural laws that apply if you have different seats of arbitration, and you will have awards that are subject to challenge before different supervisory courts. So if you have a different seat of arbitration, you're very unlikely, if not impossible, to have a compatible arbitration agreement. What if you have two arbitration agreements, one calling for institutional arbitration, maybe before the ICC, maybe before the LCIA or the SIAC, and another arbitration agreement calling for an ad hoc arbitration? Here again, you'll have to look at the specific circumstances of the case, but I think the likelihood of those arbitration agreements being considered compatible is very unlikely. What if the two arbitration agreements call for administration by different arbitral institutions? What if one calls for ICC arbitration, and what if one calls for administration by the Nairobi Center for International Arbitration? Here again, I think unlikely to find that those are compatible. With that said, in 2017, the SIAC, the Singapore International Arbitration Center, proposed a sort of mechanism that arbitral institutions could adopt for sort of cross-institutional consolidation of cases. I don't think this is really caught on in practice yet, but that might be something that we see emerge down the road. What if you have two arbitration agreements calling for the appointment of a different number of arbitrators or method of appointment? Here again, I think if you've got an arbitration agreement on one hand calling for a sole arbitrator and the other arbitration calling for 3 arbitrators, you may encounter difficulties finding that those arbitration agreements are compatible. But what if you have one arbitration agreement calling for a sole arbitrator and the other arbitration agreement is silent on the number of arbitrators? There you, again, depending on the circumstances, depending on the default rules of the arbitral institution, you might be able to find a way around this, a way to find that the arbitration agreements actually are compatible. What about other procedural aspects? What if there are different procedural requirements at play in each of the or in the two separate arbitration agreements? Here again, I think you need to start drilling down, doing some analysis, thinking about whether they are in fact compatible or not. Bringing this back to the Vis Moot problem, I think it's a really interesting wrinkle that's been added here in this regard. If I recall correctly, one of the arbitration agreements excludes any use of an emergency arbitrator, whereas the other arbitration agreement allows it. And I think that's an example, rightfully so, where you can argue that both ways. And I think it'll be interesting to see what arguments develop in the competition as to whether that makes an arbitration clause compatible or not. What about the language of the arbitration? Here again, if you have an arbitration agreement saying that the language of the arbitration is English, and a separate arbitration agreement saying that the language of the arbitration is Swahili, those arbitration agreements probably are not compatible. But you can certainly think about different variations of that. Maybe one arbitration agreement says the arbitration is to be conducted in English, but the other arbitration agreement is silent. Then you can get into some analysis as to whether or not those arbitrations are compatible or not. The last example I have in terms of compatibility is the underlying law governing the merits of the dispute, the substantive law of the dispute. In my mind, broadly speaking, that is probably, if you've got different applicable laws to the substance, that is probably, generally speaking, less of a barrier to a finding that the arbitration agreements are compatible, and therefore the arbitrations can be consolidated. But again, it will depend on the specific circumstances. Just a few comments on the last two paragraphs of Article 10, and let me just back up and we'll look at those. So Article 10 sort of wraps up by saying that in deciding whether to consolidate, the court may take into account any circumstances it considers to be relevant. So here again, a lot of discretion is built into Article 10. The ICC Court is given a lot of discretion in deciding whether or not to consolidate two or more arbitrations. But it goes on to say that the court may take into account any circumstances it considers to be relevant, including whether one or more arbitrators have been confirmed or appointed in more than one of the arbitrations, and if so, whether the same or different persons have been confirmed or appointed. It then says when arbitrations are consolidated, they shall be consolidated into the arbitration that commences first, unless otherwise agreed by all of the parties. I talked about the Dutco case earlier, and I do think that the appointment of arbitrators can be one of the real sticking points or challenging issues when it comes to the issue of consolidation. So if different arbitral tribunals, different members of the tribunal, or different sole arbitrators have already been appointed, it may become quite challenging, especially under the ICC rules, for consolidation to take place. One of the reasons for this is that in the rules there is no authority or basis for the ICC Court to revoke the appointment of arbitrators that have already been appointed. So let's say you have two tribunals in place. On the basis of the rules themselves, there doesn't appear to be any authority for the ICC to revoke the appointment of one of the arbitral tribunals. We see in some other rules, I think SIAC, for example, an ability for the SIAC Court to revoke the appointment, but that's not present in the ICC Rules, so that can make consolidation difficult, if not impossible. We've been focusing on the ICC Rules. I'm just going to briefly highlight some of the criteria that we see in other sets of arbitration rules when it comes to consolidation, the sort of different grounds for consolidation. Some of this may be inherent already in the ICC rules. It might sort of try to get to some of the same destinations as the concept of same legal relationship, for example. But in other rules, we'll see grounds such as consolidation may take place where there's a principal contract and ancillary contracts. There again, think perhaps of the construction contract where you have the main contract and subcontracts. The same transaction or series of transactions. So if you've got arbitrations involving the same or a series of transactions, they may be able to be consolidated. Situations where you have a common question of law or fact that arises in all of the arbitrations. And I think interestingly, the ICDR rules, the International Center for Dispute Resolution based in the United States, extends their consolidation provision not just to the same parties, but to the same or related parties. I think with that, I'm going to stop. I think I've been going for about 40 minutes or so, and see if there are any questions.
Thanks, Tom. Thank you very much for that very insightful presentation. I must admit, I myself have been involved in a couple of consolidations, yet I find everything you said today so helpful to take back. So thank you for that. I have a bunch of questions to ask you, yes. I will start with what you started with right at the start. And you said correctly that consent is the cornerstone of international arbitration. And consent is the cornerstone of any arbitration. To what extent, in your opinion, do the ICC rules respect party autonomy when it comes to consolidation? And in your experience, are there any limitations on the party's ability to be able to oppose or request consolidation? And I ask that in the context of the fact that under the ICC rules, it is the court which makes a decision on consolidation and not the tribunal. So how does that all play into party autonomy, and what are your views on that?
Yeah, so that's a good question. In my view, so take the first part of the question. In my view, generally speaking, the ICC rules do respect party autonomy in this regard, and to me, the answer to that is that parties, I would say, effectively give their implied consent to consolidation by signing up to the ICC rules when they know that the ICC rules have provisions on consolidation. So when parties agree to use the ICC rules, when they agree in the arbitration agreement to use the ICC rules, they are agreeing to the possibility that there may be two or more arbitrations that are consolidated into one. I would also say that the principle of party autonomy is respected and reflected in Article 10 by the fact that the ICC Court is given a lot of discretion when it comes to granting an application for consolidation or not. And I guess, what I'm getting at there is that, it's not a given that cases will be consolidated. The ICC Court will assess the situation. It will presumably hear from the parties before any decision is made. And I don't think these decisions to consolidate are taken lightly. There is sort of a detailed framework at play here. Whether the decision should be made by the ICC Court or should be made by the tribunal or maybe by the two working in tandem with one another, I think that's an interesting question. Like I said earlier, different arbitral institutions take different approaches. I can certainly see the argument that a tribunal probably ought to have more say or a little more latitude in making a further assessment of whether consolidation should take place or not. But by the same token, I do see the merit in placing this decision with the ICC Court.
Thank you. Thanks for that, Tom. And that brings me to a really good segue into what I was thinking next was the issue of enforcement. So I think in most jurisdictions have very rigid definitions. I can speak for Kenya. We have very rigid definitions of what amounts to an award and what an arbitral tribunal properly constituted is. So where there is a decision rendered on consolidation by the ICC Court, and then subsequently the proceedings go on and you have a final award, yet the aggrieved party goes to challenge enforcement of the award on the basis of the consolidation. To what extent, in your experience, have you seen that initial decision on enforcement, on consolidation, being used as a basis for declining enforcement just because it doesn't amount to a decision by a tribunal?
Yeah, I think this is an excellent question. I think that's a genuine concern. I have to say, I haven't seen this in practice, but I can certainly see, on one hand, you can say, look, this is an administrative decision made by the ICC Court. It's not a decision made by the tribunal. It shouldn't be subject to challenge on that ground. But I think the answer to that is that, you can say this. It's a procedural irregularity. If your view, if your position is that the consolidation should not have taken place, and I do think that the danger is there, or the ground can be there for challenging enforcement if the consolidation is not viewed as proper. With that said, I said at the outset, I haven't seen this in practice. What I have seen in practice is that, in my experience, the courts will be deferential, I think, to whether it's an arbitral institution, a court of arbitration, or a tribunal in these matters relating to consolidation. But despite that, it is something that parties will need to think about very carefully, what impact it may have on enforcement.
Thank you. You broke down Article 10 for us, and very, very rightfully so, you focused, Article 10C, you focused on the word compatible, which you said is where what Bethel referred to as earlier, the nuances of consolidation sometimes come in. In your experience, can you share any examples or any case studies of a matter where you may have been involved, where this issue of compatibility of agreements came into play, and how that was resolved?
Yeah, good question. I'm trying to think of one or two examples. The seat of the arbitration I've seen come up before, but like I said, that's an easy one. Appointment, a number of arbitrators. I've seen that in practice, and again, that was a real sticking point. I forget the details, but I think it was something along the lines of one arbitration agreement was a sole arbitrator, the other was three, and there it was very difficult for the Court of Arbitration of that arbitral institution to find that the agreements were compatible, and it declined to do so. I'm trying to think. Those are the examples that come to mind right now.
We actually have a follow-up question from my earlier question on the principle of party autonomy under Article 10. Are the scenarios for consolidation under Article 10 exhaustive, or can parties exercise party autonomy and amend or formulate these scenarios for consolidation under Article 10?
Yeah, I don't see any reason why the parties couldn't do that in their arbitration agreements. And again, in the Vis Moot scenario, we do have an example of that. I think certainly if the parties went to the extent of agreeing on different or additional criteria in their arbitration agreements or agreed on it at the time of the arbitration, I don't see why that wouldn't be respected by the ICC Court. Again, it's going to depend on the circumstances. It's going to depend on how that's formulated, the degree of clarity, the relevance at the time the dispute arises, so on and so forth. But in principle, I don't see why it couldn't happen.
Yeah, I suppose that just takes us back to the crux of the arbitration, the whole principle of arbitration, which is party autonomy.
Yeah.
My next question revolves around, and you spoke about it, is confidentiality and transparency. So where you have two separate claims which have now been consolidated, how does the ICC and how do the ICC rules balance the need for transparency within the consolidation process with the parties' expectations of confidentiality during the arbitration?
Yeah. Another good question. I think to answer it, ICC rules, so far as I can tell, don't really address this, and I think in large part it will be left, these issues of confidentiality and transparency in practice will be left to the tribunal in the procedural order and the proceedings themselves. I think to the, if you've got a situation where party A has concerns after party C has been brought into an arbitration and doesn't think party C is entitled to see certain documents, the tribunal will have to think about how to handle that. As a practical matter, I think it can get very tricky very quickly though, right? Because again, if you're talking about consolidated arbitration, you are talking about one arbitration. Each of the parties is a party to that arbitration, and if you're trying to maintain the confidentiality of certain documents, and that means one or more parties to the arbitration don't get to see them, then I think suddenly those parties are going to have, the parties that don't have access to those documents might have very good arguments that they're not being treated fairly. So I think the answer is it's going to be left in practice to the arbitral tribunal, but at the same time I think it's going to create some very challenging issues for the tribunal to deal with.
The next question we have is, in the context of party autonomy, would Article 10 be considered a cornerstone in ICC policy? And to what extent, such that parties are not allowed to modify that power and give it to the tribunal?
Yeah, so this is a good question. I think it is getting pretty close to some of the issues that have to be dealt with in the Vis Moot problem. So I'm not sure how much I'm going to say on this one. I'll stick to what I said earlier. I think parties can certainly exercise party autonomy and agree on certain aspects relating to consolidation in their arbitration agreements, whether, how the ICC Court would react to parties agreeing to take that decision-making power, that power to decide whether or not to consolidate, away from the court and give it to the tribunal, I think that starts to get trickier. And it's probably why this has been incorporated into the Vis Moot problem. In terms of the first part of this question, I'm not sure if this is what, or I guess the first of the two questions here. In the context of party autonomy, would Article 10 be considered a cornerstone in ICC policy? I'm not sure if this is what the question is getting at, but I think I would say consolidation is not a cornerstone of ICC policy or arbitral policy more generally. I think it's an important tool. I think for the reasons I mentioned at the outset, there are a lot of advantages to it. But I can't speak for the ICC, but I think in my experience on the SIAC Court of Arbitration, I think when in doubt, courts of arbitration or arbitral tribunals probably would err on the side of not consolidating. That being the case, I would say consolidation is not a cornerstone of whether of either the ICC rules or international arbitration more generally. I would go on to say, and this is one of the reasons I highlighted or tried to highlight this at the outset, I do think the use of coordinated proceedings is probably underutilized in international arbitration practice. I would like to see more of it. I was glad to see that ICSID expressly introduced the concept in its rules in 2022. I know in the draft SIAC rules that came out last year, coordination of proceedings is one of the new rules under consideration. I don't know if it will make the final cut this year in the SIAC rules or not, but I think coordination of proceedings can be used much more effectively and frequently by arbitral institutions and tribunals as a good workable alternative where consolidation might not be in order.
Yeah, definitely. Especially insofar as I think ensuring that there's no conflicting decisions, which then later lead to issues down the line. And I think that brings me to my last question for today, is whether the ICC rules have any mechanisms in place to address allocation of costs when it comes to consolidated claims.
Another good question. I think the short answer is no, they don't. But here again, I think that is left to the discretion of the tribunal, and it's something the tribunal will have to take into consideration and assess in any consolidated arbitration.
And I don't think we have any further questions on the chat, which brings us to the end. Unless Bethel, I'll hand it over to you if you have anything to ask.
Yes, thank you so much, Tom. I just have one question, just a follow-up question to what Radhika already asked. You raised important consideration when the court considers compatibility, one being arbitration rule, which I think is very important because you could have instances where parties agree to an ICSID arbitration rule, where you have annulment and different way of enforcing it, at least in the US. And then you have maybe an ICC arbitration rule, which does not provide annulment, and it's treated differently in terms of being enforced in the US or in any other jurisdiction. So I wanted to see your point on, is this compatibility issue also a factor considered by other ICSID arbitration maybe, or other arbitration rules, or is this specific to ICC?
No. This you will see the concept of compatibility in just about every rule on consolidation in every set of arbitration rules, if not all of them. You could say compatibility is a cornerstone consolidation. Yeah. I think brought to the fore an important issue that I've maybe touched on, but I didn't state it as explicitly as I think you did, and it's a good one. I think, whether it's the ICC Court of Arbitration, whether it's an arbitral tribunal under a different set of rules considering consolidation, I think the enforcement of the award is the driving factor behind all of these rules when it comes to deciding whether or not to consolidate.
Yeah, most definitely. And I think, Tom, no, sorry, we have one more question. Article 6.4 is on admission. I suppose the question would be, is Article 6.4 on admission of new claims or consolidation?
Yeah, so that's a good question, and again, is one of the sort of goes to the heart of the Vis Moot problem. I would put it like this: I think Article 6.4 is designed as a straightforward mechanism for admitting new claims, and I think it's sort of designed for the sort of plain vanilla arbitration where you've got a claimant and a respondent, and the claimant wants to add a new claim at a later stage of the proceedings, or the respondent wants to add a counterclaim. I'm just looking at 6.4 again. Yeah, I think it does go more to admission of new claims and not so much to consolidation.
And I think with that, we are now at the end of today's session. So I think, Tom, on our part, we just wanted to say a massive, massive thank you to you for your time today. This has been such a valuable series on consolidation. I don't think just for our students, but even for Bethel and I found myself taking notes while you were speaking. So thank you very much for your time today, and we really appreciate it, as I'm sure all the students do as well.
Thank you.
And I will now,
real pleasure.
I'll now hand over to Bethel.
Yeah, I reiterate what Radhika has already pointed out. I was very looking forward to this discussion as well, because it's really something that comes up in a lot of arbitration these days, and you have seen different arbitration institutions adopting the move towards designing a system for consolidation and clarifying the rules as well. So it's been great to hear your thoughts on it. I think the key takeaway for me is compatibility is the cornerstone of consolidation, which I think this is a big tip for our students as well, to think about consolidation in terms of is it compatible or not to those factors that you've highlighted out. So I'd love to thank you again on behalf of the students, Africa and the Moot, and myself for giving us a very interesting discussion on consolidation of claims.
Well, thank you very much. It was a real pleasure, and best of luck to everyone taking part in the Moot. The Vis Moot has really become, it has been for years, a real phenomenon in the international arbitration community, and I wish you all the best, and you'll learn a lot.
Thanks, Tom. Thank you for your time.
Thank you.
See you, everyone.
Bye.
Bye.